Hello, YouTube. I'm Vince White, and I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We got a question here from YouTube user I am Sam 713, who says, I am a licensed federal attorney and an aspiring plaintiff side employment attorney. Very cool. We need more plaintiff side employment attorneys desperately. Back to the question. Can I represent myself against my employer for failure to accommodate and retaliation, or would that be a conflict of interest? I have already sent a preservation of evidence letter. I'm still technically employed, but on medical leave. I feel as though I have been constructively discharged at this point. I was investigated during my leave, and they refused to tell me the specific hardship that my accommodation would cause the company. Thank you. Okay, so let me think through your ethical duties, and just real quick, check with an ethics professor, check with an ethical authority, because you're worried about a conflict of interest. And then I'm not an ethical professor, although in this industry, and I think you will find, because you're an aspiring plaintiff side employment attorney, we do wrestle. We have to make sure we're paying attention to the ethics a lot, because there's a lot of situations where normal run-of-the-mill attorneys might not run into some of these questions, but because we're doing complex litigation and there can be sizable sums of money involved and profit motives and everything, wild situations arise, and you've got to keep your eye on the ethics. So it's important in this field in a way that it's often not important in other fields. Obviously, it's important for all attorneys to do the ethical thing, but we come into quirky, novel ethical questions way more often than some other fields. Now, listen, fundamentally, you have the right to be pro se. Everyone's going to say, hey, any attorney who has himself or herself for a client is a fool. Very true. I think you representing yourself is essentially self-loathing and self-harm. You're just engaging in self-harm. That is true for all pro se litigants, even for federally admitted aspiring plaintiff side employment attorneys, right? I just think I would think myself a fool if I represented myself, right? Now, there is one further issue here. You are an attorney. You have an employer. Are you working as an attorney in your capacity as an attorney for that employer? Because that then raises the specter of the conflict of interest, right? You have then this duty towards your client, who is your employer in that scenario, right? In-house counsel, their client is their employer. And my concern would be that because of that duty, representing yourself would potentially be seen as a conflict. Now, get that checked out with a local ethics expert. But the reality of it is, I don't know that could be true, because representing yourself doesn't actually change anything, right? It's not like if you're bringing a claim against your employer, which is fundamentally your right under these laws. Let's play it this way. Let's say you're an employment defense attorney working in-house for a corporation, and you need an accommodation for your disability, and your employer says no, they're not going to grant you this reasonable accommodation. Is your employer your client? Yes. Does that mean that you cannot pursue your claim? No. I think fundamentally you can pursue your claim. They've failed under the law. You can bring your claim. Now, what's the functional difference, ethically speaking, if you represent yourself or if you hire counsel? How does the conflict change? Is the conflict of interest any different in that scenario? And I don't see how it is. So I suspect ethically the answer is, yeah, you can represent yourself the same way you can bring the claim against the employer. Yeah, sure, you had a duty to the employer, and there's a tension there because you had this duty to the employer and now you're going after the employer. But you can't not pursue your rights, right? You don't, in becoming an in-house counsel or working as an attorney for your employer, you don't give up your fundamental rights against discrimination, or the right to be accommodated for your disabilities, right? That, or the right to be free from sexual harassment. You can you imagine? Every in-house counsel in the country can be sexually harassed, can experience discrimination. We can fire you for your age. We can fire you for your race. We can fire you for your national origin because you are in-house counsel. And I'm not mocking you. I'm mocking my own thought process, to be clear. And you can't pursue your claim because you have a duty to your employer. And I think that's simply not the case. That doesn't make any sense, right? So I actually don't see the difference if you're representing yourself or if you're the claimant and you have counsel, right? Like, what's the difference? You're still in conflict with the employer. And it's clear to me, it's very clear to me that you can still pursue your claim. So I don't know that I believe it makes a difference whether or not you represent yourself. That being said, I am not a foremost expert on legal ethics. And I do keep a professor of legal ethics on speed dial so that I can call him when a novel ethical issue arises. And I can say, hey, what's the happy haps, professor? I got questions because I got to make sure we're doing the right thing here. And, don't be afraid to avail yourself of the same. Although, listen, get a better deal. Mine charges me tremendous sums of money for his well-reasoned legal opinions. So, hopefully yours doesn't charge you, or at least charges you less. But anyways, I'm sorry you have to deal with this problem. I'm sorry about the medical leave. I'm sorry about this conflict with your employer. I hope that they make you whole. I hope you win what you deserve. And I will be cheering for you. And welcome to the industry. I'm sorry that you are potentially your first client, but welcome to the industry. I'm thrilled to hear that you're going to be a plaintiff side employment attorney. We needed you. Now, if you can find like 30 to 50,000 more of you, that would be swell, and I could retire. Would I though? Would I retire? I don't know. Probably not. I don't think so. I mean, someday, but not today. Not today. Retirement. Anyways, if this was helpful, like, subscribe, comment down below, share the channel so it may grow. And in the comments down below, listen, if you disagree with me on where I came down on the ethics of this, let's chat about it, right? Let's have a conversation. If you think I'm dead wrong saying that pro se, representing yourself or being an attorney and representing yourself is engaging in self-harm, let's talk about it. I've been saying that for a long time. I know not everybody agrees with me. Listen, I know pro se litigants who have done great. There is a YouTube channel for someone who was primarily pro se for most of their case who did phenomenal. Right now, listen, she did have counsel for the final push of that case. And I think it's of note that she's in fact like an actual rocket scientist, right? Like that is a relevant factor in terms of her ability to run a case intelligently and jump through all the hoops and see all the connections and, get the evidence where it needs to go and, get the paperwork done and make the filings and make the arguments. Like, I think that's relevant. But that being said, certainly I know a handful of extraordinarily successful pro se litigants. So when I say that I think that pro se litigation, representing yourself is self-harm, there are of course exceptions. I would just contend those exceptions prove the rule. Anyways, take care, everybody.